Good morning, everyone. This is Parsai, live from Toronto, talking about the latest developments in the world of immigration to Canada and also answering your questions. We are live through the labor long weekend. So this means that the schools will open on Tuesday, and also the big news about immigration to Canada is that the government of Canada will open the borders to travelers to Canada. This means that if you are fully vaccinated starting from September 7th or Tuesday, you may travel to Canada with a proof of vaccination. Of course, you need to keep in mind that we have already entered the fourth wave of COVID-19 in Canada. The number of cases are increasing significantly. Having said that, because majority of people are fully vaccinated, the cases, the severe cases and death rates are low. However, we are still dealing with coronavirus, and that could convince the immigration authorities to change their mind about opening the border or shut it down very soon. So I expect that Tuesday will be a super busy day for Canadian airports and also land crossings. So we'll see that. And if you want to travel to Canada on or after September 7th, first of all, follow the news. For example, visit settler.ca. We publish news over there and see if you meet the requirements. For example, you need to be fully vaccinated. This means that you need to show proof of vaccination to the immigration authorities. They ask you to upload your proof of vaccination to an app called ArriveCan. I write the name of it in the chat box. And I have an article about ArriveCan, and I will post the link to that article below this video after we're done with the live session. But anyways, you need to have proof of vaccination uploaded to ArriveCan, have a quarantine plan, and then if there's, of course, you need to be symptomless. If they find out that you meet the requirements, they will allow you to travel to Canada, and they will allow you to enter Canada without the need for quarantining and those kind of things. In terms of again, I repeat that this could change at any point of time because the government of Canada will reduce they want to reduce the number of cases in Canada, and we know that the cases have increased recently, so they may change their stance. We still don't know if they are going to do that, and if they do that, how and when they will do it. But for now, what we know is that on September 7th, they will open the borders to everybody who is fully vaccinated. And many of my clients are actually coming to Canada on or after September 7th. Just to introduce myself, my name is Al Parsai. I'm a regulated Canadian immigration consultant. I teach immigration consulting at Ashton College. I am the author of this book, 88 Tips on Immigration to Canada, which has been identified as the bestseller on Amazon.ca under the immigration law. I have also been practicing since January 2011. So it's almost 11 years of practice. I have had clients from more than 50 countries in the world. And today, what I'm going to do, I will review the latest news in the world of immigration. And if there are any questions, you can post those questions on the chat box. And if they are general questions about immigration to Canada, I will happily answer those questions. So let's go through the latest news as quickly as possible. So the first thing that you want to know is about the issue of Afghanistan and the unfortunate situations that are going over there. So you might like to know that the government of Canada has already transferred 3,000 Afghans to Canada. under their expedited program to resettle Afghan citizens to Canada and offer them protection. They are also expediting the processing of IRB cases, that is, those refugee cases that they have filed for refugee inside Canada or at the port of entry, and they are Afghan citizens. And there are also some other programs that are going on in terms of resettling Afghan citizens. So you can follow those as well. The other piece of news that I talked about was Canada to welcome fully vaccinated foreign travelers on September 7th. Again, if you want to know more about these, I will post the links below this video as well. But here is in the chat box. By the way, if you have any questions, just post them on the chat box. I will definitely answer them. You don't need to repeat your question. When I'm done with the news, it will take about 15 minutes. Then I will answer your questions. Okay. So the next thing that you need to know is that Quebec has become again active in terms of inviting candidates to their province. In fact, last week they invited more than 1,600 people for immigration to the province of Quebec under two different major programs. They even identified some job categories and invited people under those categories. For those of you who are interested in immigration to Quebec, keeping in mind that Quebec is one of the provinces of Canada. It has a special agreement with the federal government in terms of immigration, and that means that they will accept immigrants and for their own province, and their focus is on those people that they are either francophone or they know French language, the French language very well. And if you want to immigrate to Quebec, then you need to visit their website directly and apply or consult with somebody who has a license to help you with immigration to Quebec, and they will help you. I don't have a license for Quebec. I don't practice immigration to Quebec, but I deal with immigration to federal and most of other provinces. The only provinces that I don't work on are Quebec and Saskatchewan. Again, if you have any questions, please post your questions, and then I will definitely get back to you and will answer your questions. So keep on, stay online, and I will answer your questions after I'm done with the news. And you don't need to repeat your questions. Okay, so the other one that is very interesting is that since COVID-19, many entities, they were trying to push the Canadian government to offer amnesty to unauthorized workers that they are already inside Canada and they are stuck. The government has not quite responded to those requests, but at least in terms of those workers that are already inside Canada and they have been working without authorization in the construction business inside a Greater Toronto area, the government is going to make some of those people permanent residents. And this amnesty is only extended to those people who entered Canada with a valid visa or documentation. They have been in Canada for at least the past 5 years. And in the past 5 years, they have worked in construction business in the Greater Toronto area for at least 3 years. There are certain steps that they need to take. The cap on this program is 500. So as soon as they reach 500 applicants, they will shut this program. If you know somebody who has been working in Greater Toronto area in the construction business and they have been doing this without having a proper work permit and authorization, please let me know, and I will be more than happy to try to assist them. We have actually I posted something about this. I just posted a link here. I will later post the link below this video as well, so you know what's going on with this program. But it is not open to everybody. It's very limited to people who worked without authorization under the construction activities, and there are certain knock codes and for the at least for 3 years, and they have been in Canada for at least 5 years. The other issue is about, of course, Afghan nations and Afghan nationals that the United States and Canada has agreed to collaborate to assist them to come to Canada. You also need to know if you're a practitioner, if you're an immigration consultant or immigration lawyer. I'm delivering an advanced course in the field of immigration. It's called Advanced Certificate in Temporary Residence to Canada. If you're interested and you want to know more, this course will be delivered by Ashton College, and by the end of the program you will receive a certification, but you need to be a practitioner. So you're already an immigration consultant, a regulated Canadian immigration consultant, or immigration lawyer. So if you are one, or if you know somebody, our first session will be on September 8th. So Wednesday will be our first session. The course will be one day per week, and it will extend for a while. I think the last session will be sometime in November or December, but hopefully by the end of it, you will have a deep understanding of temporary residence in Canada. And the last thing that you want to know is that if you want to immigrate to Canada as a self-employed person, then you can immigrate to Canada, but you need to be a self-employed person in cultural activities or athletics. And there are some immigration programs available to those people. I've already written some articles about immigration for athletes and artists in Canada. But if you want to know more, I just posted a link here. I will post a link below this video as well, and you can take a look at it. And if you qualify, then you could consider immigration to Canada as a self-employed athlete or self-employed artist. So I think I'm pretty much done with the news. Let me see. Oh, one more thing, and then we're done. You need to know that Canada suspended flights from Morocco. So this means that on top of India and Pakistan, Morocco is also added to the list. This means that if you are a citizen of Morocco, you cannot directly fly from Morocco to Canada. Again, this is about coronavirus and the number of cases that they exist over there. I just posted the link again here in the chat box, and I will later post it below this video. Okay, let me take a look at the questions as well. So the first question is from Kirtinithi Lamasal. Can unvaccinated extended family members travel to Canada with travel authorization and quarantine plan? So the simple answer to this question is yes. So if you have an extended family member who is not fully vaccinated and they want to travel to Canada, then they need to go through the authorization process. This means that assuming they already have a visit visa to Canada or an ETA to Canada and they want to travel, there is a form called IMM 006 that you need to fill out. They need to sign it. You need to sign it here, but with a notary public. And then there's a bunch of other documents that you need to prepare. Email them to the immigration authorities and they will review them. If they approve it, then they will issue an authorization and your family member can travel to Canada with that authorization. If they do not hold a visa to Canada and they are from a visa required country, in that situation, you need to prepare a visa application along with IMM 0006, upload everything to, and then request an exemption as well. So if they approve, they will issue both the visa and also the authorization to travel. I have an article about extended family members, and let me just write this down here. So I will post the link below this video, but just to be on the safe side, I also posted in the chat box for your information. There's also something else that you need to know. Because government is moving towards vaccination, this policy could change. First of all, when they introduced this policy of issuing exemptions for extended family members or immediate family members, they initially were processing those applications in 2 weeks. Nowadays, it could take months before they actually issue an authorization. And this means that they're basically are not that much interested into issuing those authorizations. And so number one on their list is vaccination in full, not getting the authorization. But the authorization is still in effect. You can apply, and hopefully they will issue it. So the next question is from Kartik. I withdrew a file because of mistakes in that then I refiled, but forgot to mention about the first file, then erased a web form and told about that. Is it okay? It's a study permit. So unfortunately, I cannot comment on that because I don't know about the specifics of your case. But generally speaking, your case talks about misrepresentation. So if the immigration authorities find that somebody is withholding a material fact from them, then they will consider that misrepresentation, and they could, not necessarily, but they could make that person inadmissible to Canada for a period of 5 years. Now, if that person, prior to the officer's decision, tries to fix that issue, so informs them about the situation, explain why the mistake was happened, then the chances the officer goes in the direction of misrepresentation are very low, because they see that you have been open and honest with them. But at the end of the day, it's the officer's decision. It's not mine. And I don't know about the specifics of your case. But generally speaking, being open before the decision by the officer or before receiving a PFL letter, and PFL stands for Procedural Fairness Letter, that reduces the chances of becoming inadmissible to Canada extremely. Okay, so the next question would be, by the time my PR card, so that question is from Sangeet Sirchandan. By the time my PR card expires next year, I don't meet the 730 days criteria for PR status. How to navigate this scenario? Also, will there be an issue post-expiry in terms of anything such as job change? Okay, so of course, again, if you want me to review your specific case, you need to book an appointment with me. It's not free. I charge $200 for half an hour of consultation, but we will review the case together to see what are your options. But I definitely can offer you a generic answer to this question. So when you become a permanent resident of Canada, for every 5-year period, the expectation by the immigration authorities is that you spend 40% of your time inside Canada. That's all they expect. So it's not a huge expectation. What they expect is that a person spends 40% of their time in Canada. That's 730 days out of every 5 years. If a person doesn't meet that 730 days, or if at the time of examination, for example, when you're entering Canada, a border officer finds out that you are not going to meet those number of days, then there is a chance that they will cancel your permanent residence. So this cancellation of permanent residence could occur either by a visa office when you are applying for a PRTD or permanent resident travel document, or it could happen through a process of removal order. It means that you are at the port of entry, the officer realizes that you do not meet the requirements, or you have not met the requirements, or you're not going to meet the requirements, and then they will interview you and they issue a report 44, and based on that report they issue a removal order, which is a departure order from Canada. Keep that in mind that by default, when I say 40% of the time, we're looking at physical presence in Canada, but there are some exceptions to the physical presence. For example, if you have been hired by a Canadian company and they deploy you to another country, then you could count the number of days that you spend outside Canada as residency requirements. Having said that, many people, of course, they have tried to for the lack of better words, deceive the government, and they came up with made-up corporations, and then those corporations send them outside Canada. So the government and the immigration officers are aware of that. They are very sensitive. They want to make sure that this deployment is actually a real thing. So for example, that I give you an example. So if RBC, which is the largest bank in Canada, hires somebody and then they send that person to work in their office in, say, Dubai, then that is a legitimate transfer. But if somebody just establishes a business here in Canada and then goes outside Canada and say, oh, I'm working outside Canada because of my business inside Canada, then that's not usually a legitimate request. So you have to be very careful. Another exemption to this is for people who have been hired by the government of Canada or provincial government or the Canadian Army or armed forces, and they are sent outside Canada. Another example is somebody who has a spouse or common law partner. That spouse and common law partner is a Canadian citizen, not a permanent resident, a Canadian citizen. And that spouse or common law partner has to leave Canada for job or other reasons. And you are accompanying that spouse outside Canada. In that situation, you can meet the residency requirements even being outside Canada. These exceptional situations exist. Now, if somebody doesn't meet the exceptional situations and they do not have the 730 days of inside Canada, the only way that they can retain their permanent residence is to show that there were some humanitarian and compassionate reasons, including the best interest of a child, that allowed them or forced them to be outside Canada or allows them to come back to Canada. So, of course, this is discretionary. My experience is that most visa offices, they do not accept this. But at the end of the day, if the visa office accepted, then you will retain your permanent resident. If they don't and they refuse your application, or at the port of entry, they, despite bringing up the humanitarian reasons, they issue a removal order, then you can appeal the decision to the visa, to Immigration Appeal Division of Immigration Refugee Board of Canada. If you win the appeal, you keep your permanent residence. If you don't, you lose your permanent residence. That's a very, very quick and broad explanation of that. Of course, I have dealt with many hearings related to appeal of residency requirements, and I have seen the ups and downs of this. So if you're serious about knowing your options and what you can do to save yourself, I highly recommend that you book an appointment with me and we can discuss this in more details. We have another question. The question is from Katrina M. My question is regarding Canadian Experience Class to PR. Can my partner apply for his PR with me as a dependent common law even while I'm awaiting a visitor visa? And so if somebody is applying under Canadian Experience Class, again, I don't know about the specifics of your case, but I explained this. So when you're applying for permanent residence of Canada, you need to include all your dependent family members. Now, if they are not accompanying you to become permanent residents, you mention that. If they are accompanying you, you mention them. Because you're responsible to declare all your dependent family members. The inadmissibility of a dependent family members make you inadmissible to Canada. So the government wants to see that you actually, when you're applying for Canadian Experience Class, you include your common law partner. So that's a must. It's not that whether I can or I cannot. Now, if your common law partner does not want to immigrate to Canada, you mentioned that the common law partner is not accompanying me to Canada, but still you need to mention that there is a common law partner, and that common law partner is whether accompanying you or not accompanying you. The question is, who is a common law partner? A common law partner under the immigration law. So forget about the local laws, because the local laws that we have in Canada, they differ from immigration law. But if you look at the immigration law, under the Immigration Refugee Protection Act, a common law partner is somebody who has cohabited with you for at least 1 year. This means that you live together for at least 1 year under the same roof. You are in a committed conjugal relationship. It means that you are intimately, emotionally, and financially dependent on each other and committed to each other. If you can prove those things exist, then yes, that person becomes your common law partner. And when you're applying for Canadian Experience Class or any other type of immigration to Canada, you must include them in your application. If they are not accompanying you, you need to mention that, but you also need to come up with an explanation why on earth your common law partner is not accompanying you to Canada. So you need to have an explanation for that as well. In terms of visitor visa, I didn't quite get your question. If you meet the requirements of Canadian Experience Class, you enter the pool of express entry and apply. Now, whether you are inside Canada or outside Canada, you have applied for a visitor visa or you have not, or you have applied for PGWP or not, that's a different story. For immigration to Canada, your temporary status in most immigration cases, including but not limited to express entry cases, is not important. Unless you are claiming points for that. That's a different story. Okay, so where am I? So how does artificial intelligence work in processing of a study permit, if it does? So that's a question from Kartik. I didn't get your question. I don't know what your question is about. How does artificial intelligence work in processing? So if you could elaborate on what you mean by this, I will happily answer that question. So there's a question by Aisha. Hello, Mr. Parsai. I had a consultation with you before, and now I need another one urgently today. Can you send me a payment link along with a discount link, or today I'm under a deadline? So Aisha, please send me an email. You have my email address, because right now in a public forum, I definitely cannot do that. But if you send me an email, I will look into that. Today, as you know, is a Sunday. So for at least for the next few hours, I'm engaged with something after my live is over, but I'll see what I can do. Thank you very much. Okay, so another question. So Kartik, I think now I got your question about, so review has not started, not even medical has updated till now. So if you're talking about the processing times of study permit applications, so the government focused on those study permit applications that they were submitted on or before May 15th, 2021. They processed most of those applications. But if you have submitted an application after May 15th, 2021, it's very likely that your application is got stuck. So, and unfortunately, this is because of the closures of many visa officers or slowing down of many visa officers and processing centers. This is normal. Having said that, you can get in touch with them through IRCC web form. And so let me, IRCC web form. I have a video about IRCC web form. If you don't know how to use IRCC web form, you can watch my video. Let me just give you a link. So here's the link to that video. You can watch that video, and hopefully it will show you how to communicate with them and follow up about your medical, etc. So the next question is by M. Hello, my UCI got changed in reapplication from different GCQ portal, even though I filled a previous UCI in the form. What would be the reason? What is the solution? So unfortunately, these things could happen because of the mistakes made by the immigration authorities. So sometimes it's a clerical mistake. I mean, you submit an application and an officer behind the scene make a mistake and issue a new UCI for you. If obviously your new UCI stands because you are dealing with that UCI, but you can communicate with them and let them know that this mistake has been made, and they will decide whether to amalgamate the information from the previous UCI with the new one, or maybe they replace and they just won't do anything about it. So sometimes they make that mistake, but that's their mistake. And remember, UCI is a number that is attached to you as a person. And it's a good idea that it doesn't change, because now you have your history. For example, if I today ask whether CBSA or IRCC what kind of information they have on me based on access to information and privacy, and they have my UCI, and UCI has not changed. When I give them my UCI, they can give me the whole history of my interactions with the immigration authorities. If this changes, then there will be a break because they don't have some of the information, or they may mix it up. They might think that that person is another person. So it's not a bad idea if you try to resolve it, and that could be usually done by submitting a request through the IRCC web form. Having said that, if you want to consult with a professional to know your options, you can get in touch with somebody like me, ask them, show them the discrepancies, and they will decide which direction to take. So the next question is from Param Saini. Sir, I reply my file on July 1st, but okay, so this is the same thing about UCI changes, due to which my biometric not shown in my GC key. What can I do? I raised a web form 20 days ago, but my biometrics do not show. Give me solution to change UCI. Again, this is a request. You need to, again, I don't know about the specifics of your case, but as I mentioned, the only way that we can do that is just by communicating with them and let them know what's going on. Unfortunately, IRCC is not always very responsive. If IRCC was a company and people wanted to give them stars, I wonder how many stars they would have given them out of 5. Their communication system lacks, a proper way of communicating with people. They don't have a specific, complaints department. They don't have easy means of contacting them and fixing the issues. But do your best. Hopefully they will fix it. Otherwise, you will end up doing the biometrics again. Okay, so this question is not from me. For me, the other question is Anisha Gordon. After doing my biometrics and I received my AOR, how long will it take for IRCC to make a final decision? Okay, so the simple answer is that I don't know. And I will tell you why. Because first of all, the processing time, even before COVID-19, highly dependent on several factors. So one of the factors was the type of application you're making. So some applications were being processed in a matter of days. Some of the applications were being processed in a matter of several months, and sometimes several years. The other issue is that it's not just the type of application, which visa office is processing your application, because some visa offices were quicker in processing certain applications comparing to other visa offices. And I remember when I started my business as an immigration consultant, in fact, the immigration authorities used to post the processing time based on the visa office, because each visa office processes applications at a different pace. The third is the specifics of your own application. I mean, the merits of your own application. What if there are some complexities in terms of background and other issues? And that's why the processing time could take way, way longer. The last one probably is the attitude of the officer. Some of the officers scrutinize an application. Some of them, they don't. Some of them are easygoing. Some of them, they are not. And because of that, you cannot predict the exact processing time, even an estimate of the processing time. But nowadays, it has become even more complicated because of coronavirus, because many of the offices they do not work anymore, or they do work, but they only focus on essential issues. I give you some examples. For example, the visa office in Sydney, Australia, they pretty much do not process any requests unless the request is essential. We have the same situation with the visa office in New Delhi, the visa office in Bangalore, the visa office in Ankara, the visa office in Warsaw, and many other visa offices that they are not that much responsive. There are some visa offices that they do their job, like Bogota in Colombia, or the visa office in Singapore. But beyond that, some of the visa offices are extremely slow, and that unfortunately delays everything. And that's because of coronavirus. We do have the same situation with many case processing centers inside Canada. For example, Sydney, Nova Scotia, it's extremely slow. They have not issued file numbers for many applications since, believe it or not, March 2020. And then we have CPC Mississauga. This one works, but very slowly. We have CPC Edmonton. It only works on exceptional situations. But for example, the visa office, the processing center in Vancouver, which works on humanitarian cases, they are doing their job relatively okay. So that because of those reasons, the processing time has elongated significantly. And unfortunately, nobody can answer your question. And especially because I even don't know what kind of application is that. But even if I knew it, honestly, because of coronavirus situation, nobody can. Just be patient. The only thing that I can say, be patient, expect delays. So Janet says, hi, I'm an asylum seeker in Hong Kong. Okay, so for asylum seekers, if you're outside Canada, unfortunately, it's outside my area of expertise. I don't deal with resettlement of refugees to Canada. If you are inside Canada, or if you show up at the port of entry and you need my help for refugee, I'll happily accept your case. But for outside Canada, I don't know how to handle resettlement. So I don't know what's your question, but even if there is a question, I cannot answer that question. So the next question is from Ravnit Jill. Hi, Parsai. What kind of financial documents required to apply for a student visa under SDS category? So SDS category is relatively straightforward because they are asking for two things. Number one is that you have to pay 1 year of tuition fee. So this is the money that you have already paid to the college or university. And for those of you, by the way, that you don't know SDS, it's a study direct stream, and it is limited to certain countries. Now there are 14 of them that you can apply under that program. It's an expedited study permit application. For example, if you're from China, if you're a resident of China, if you're a resident of India, if you're a resident of Senegal, and many other countries, then you can apply under this program. This is just for fast processing study permits. It has nothing to do with approval rates. So it doesn't mean those people will be approved better than other people. It's just that the processing time is less. So one of the things that you need to show for that is obviously you need to take an IELTS test, either academic or general, and you need to show that you are CLB 7. It means that your score is at least score band is 6 under each ability. But in terms of financials, you need to pay 1 year of tuition fee of the college or university, and you need to show that you have already paid that. The second one is that you need to purchase a GIC, which is Guaranteed Income Certificate, from an approved financial institution. Those financial institutions are in Canada, like Scotiabank and other institutions. So these are the two major financial requirements from SDS stream. You have already paid the tuition fee for 1 year. Second of all, you have purchased a $10,000 GIC. In this case, they know that they are financially sound, and at least they are not worried about your financial situation. But of course, I highly advise that you also show other financial resources, like a source of income or some money in the bank, just to prove that when you're coming to Canada, you can cover your personal expenses in Canada. And of course, you can show bank accounts or other financial instruments if they are under your name or under the name of the person who is covering your expenses. So if a child is coming to Canada, a young person is coming to Canada, and their parents are covering their expenses, then they need to show that their parents have money. If a relative inside Canada is covering their expenses, then that relative needs to show their relationship. They need to proof of money, and the proof, and also they need to provide enough documentation that their intention is to support that person. If you have received a scholarship or bursary from a college or university in Canada, you also include those to show that you have no issues financially. So that's a very generic, of course, thing. We can go into the details depending on the situation. So the next question is from Taha. Hi, Sarah. I submitted an application for work permit online from Bahrain, but I couldn't submit a PCC for Qatar and send an explanation letter stating that there is no Qatar embassy in Bahrain. Okay, I don't know what your question is though. But if you're talking about whether there will be a problem or not, obviously I don't know, because that depends on the immigration officer that reviews your application. Whenever we cannot provide a police certificate, then we try to come up with explanation. Generally speaking, when you're applying for a work permit, you do not necessarily need to submit a police certificate. However, my experience says that for certain nationalities and certain visa offices, they ask for police certificates anyways. For those nationalities and for those visa offices, I upfront ask my clients to provide police certificates to avoid further delays in the processing of their application. But this is not a must for work permit application. Having said that, if you provide police certificate, that shows your good character. So I highly recommend it for every work permit applicant. And also, if you cannot provide, then it looks like that you did the right job to explain it. But I personally ask my clients to do an affidavit, not just an explanation letter, to show that this is an evidence. But at the end of the day, it's up to the officer whether they say they accept those documents or not. And that's not my role to guess even what an officer may ask. Obviously, for my own clients, because I know the specifics of their case, then we look at their documents and we judge them, and then we tell them that what kind of changes they need to make. So the next question is from Hiran Patel. Sir, currently my file is in RCIC. As a self-employed person, I got my permanent file number. Can I also apply in some other type visa like visitor, etc.? So first of all, CIC changed its name, Hiran, to IRCC in 2015. So it's been almost 6 years that we don't say CIC. So CIC stands for Citizenship and Immigration Canada. They changed the name to IRCC, which is Immigration, Refugee, Citizenship Canada, just to let you know. But in terms of application and another type of application, we have something called dual intent. And actually, I have an article about dual intent on my website. You can also read that. I will post. Oh, I have a video as well. So I post the link here. You can watch the video about dual intent, or you can read the article, or both. But generally speaking, under Section 22 of and thanks for just to let you know, because CIC is gone and IRC, and I know even if today you go on some older texts of IRCC, you will see that they're still saying CIC. Anyways, so when you're applying, if you have applied for permanent residence, or you intend to apply for permanent residence, under Section 22 sub 2 of the Immigration Act, an immigration officer cannot refuse your application based on that. So they cannot refuse a study permit application, a visitor visa application, or a work permit application because that person has a permanent resident application. Obviously, they need to look into Section 179, and Section 179 is that it says that when you are getting a temporary visa to Canada, you have to prove to the immigration officer that by the end of your stay, you will leave Canada. In other words, you don't have the intention of remaining in Canada without authorization. And now people might find it contradictory with a permanent resident application. It's not. They basically say, as long as you are temporary in Canada, you need to respect the terms and conditions of being temporary. Now, eventually, if you become a permanent resident of Canada, good for you. Now you are a permanent resident of Canada. So you can apply, generally speaking, you can apply for a visitor visa, work permit, or study permit. But in terms of what we can do, the processing time for self-employed applications is very long, especially nowadays. The government officially increased that to 34 months. It means from the time that you submit the application and you receive your AOR, or acknowledgement of receipt, to the time that they process your application. We expect roughly around 3 years of processing time for most applicants. Of course, in some cases, it could be way sooner. In some cases, it could be way longer. So if you want to compensate for that, there is an option to apply for a work permit as an entrepreneur or self-employed person. Come to Canada and start your self-employed activities in Canada. We have many clients that they apply under that program. And of course, this is a dual intent situation. But if they receive their work permits, they come to Canada and they start their work as a self-employed artist or athlete in Canada. This has two benefits if they receive their work permits. Number one is that they enter Canada sooner, so they don't need to wait 3 years or 4 years or whatever to enter Canada. Second one is that they also convince the officer that they have the intention and ability to be self-employed in Canada, which enhances their permanent resident application. If you are interested in this program, you need to know that you need to have money. If you don't have money, don't even think about it. You need to show that you have the ability to invest in Canada significantly and contribute to the Canadian economy, culture, or athletics. If that's the case, then get in touch with us privately, fill out our assessment form for work permit. We will evaluate that. And if we find out that you qualify, then we will tell you, we will give you an offer. You can hire us and we help you with the work permit application. But again, if this is something that you want. So the next question is from Kartik. Section 40 can only be applied when I can induce an error, not an innocent mistake, I guess. Well, Kartik, I wish this was the case. We have, because the immigration authorities need to judge whether it was an innocent mistake or not, and not you. So we can present enough documentation to show that this was an innocent mistake, but it is up to the immigration officer to see if they believe that this was an innocent mistake or not. And as I mentioned, it's way different to show that before receiving a PFL than after receiving a PFL. Because if you receive a procedure of fairness and you try to convince them that this was an innocent mistake, it will be a very tough job. But again, there also, this is a broad case and I cannot delve into the topics. But what I can tell you is that the standard of proof for immigration authorities for misrepresentation is to a reasonable ground to believe. So it means that if they look at the case and they say a reasonable person will say this was not a innocent mistake, then they could still issue Section 40. And that's the problem with the misrepresentation. And I wrote an article a few months ago about, or I think it was a video, about rising number of misrepresentation cases in Canada. Both an article and a video. I can share this link here and later post it under my video. And you can also read that. The number of misrepresentation cases has increased significantly recently, or at least based on my experience. I don't know whether because I have written many articles about misrepresentation, but people send me messages on a daily basis that they have received procedural fairness letters from immigration authorities, or they have been identified inadmissible to Canada because of misrepresentation. So it's a delicate matter. I hope nobody encounters that, but it does exist. So the next question is from Sanjit. Thank you for the answer. I'm already in Canada and the border officer allowed me in. Would definitely take your help by booking appointment. Yeah, it makes sense. If the border officer allowed you in, that makes a huge difference because you have an edge. But we can discuss that if you book an appointment, that what are your legitimate options and what steps you could take to protect yourself, and if you have family members, potentially your family members. So the next question is by M. Can I withdraw my file and relodge on the same day, or do I have to wait for withdrawal confirmation? Generally speaking, again, I don't know about the specifics of your case, but generally speaking, people could have concurrent files. And in most cases, not always, in most cases, opening concurrent files, especially with federal government of Canada, does not cause problems. In the past, we had some guidelines in terms of concurrent files, and we still do have some guidelines for concurrent files under citizenship applications. But for non-citizenship applications, in most cases, whether they are temporary applications or work permit permanent resident applications, opening concurrent files, in most cases, they do not cause trouble. Having said that, we need to make sure that there are not contradictory information in those files, because you withdraw a file, and even if they approve the withdrawal, it doesn't mean that your information will go away. Your information will remain in the system for a very, 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 very long time. So even they keep your documents for at least 2 years. So thinking that just withdrawing will give you the opportunity to submit a new application, which could be contradictory to the first one, that's not an option. But again, I don't know about the specifics of your case, so I cannot give you advice whether you can withdraw and at the same time apply again. So how fast does Edmonton visa office process my study permit is located there? So Kartik, I have mixed feelings about the Edmonton office. So I have had applications that they were transferred to Edmonton office because of their urgency, and they process my application in less than 3 weeks. And I have cases that they have been stuck there for more than a year. And they haven't processed that despite several follow-ups with Edmonton office. So sometimes they process the applications fairly quickly. Sometimes they process applications very, very, very late and with extreme delays. I'm not joking. It's so unfortunately I don't know, but just try to push them, send them documents. I know that at one point of time they decided to, because all the caregiver applications, they are in Edmonton. So the government promised that Edmonton will focus on caregiver applications for a while. So maybe they have changed their resources, their attention towards caregiver programs for now. But if your application is being processed in Edmonton, just send them IRCC through IRCC web form request for expediting the application. Hopefully they will listen to you. So again, this is from her end, recently emailed to provide additional documents like travel history from submitted to CIC through web form. I also got a permanent file number in March 2020 in self-employed category. So what is the status of my application? Well, again, I cannot comment on your application, but if they have issued a file number for you, they mentioned that this is the time that they received your application, this means that your application is in the system and is waiting to be processed. And I know that they say that, if you check the ECAS system, they say that your file is in process. But to be honest with you, that doesn't mean anything. They may just have your file may have stuck somewhere in Sydney or Nova Scotia, or maybe they have transferred it to visa office and it's just collecting dust right now. It's on a shelf and just waiting to be processed. It's not an actual processing. The processing of a file typically is a matter of few hours. In most cases, it rarely happens. An officer needs a few days to process an application. So when you see that you have to wait 30 months before they process your application, it doesn't mean that they have been processing your application for the past 30 months. But again, I cannot offer advice on your case because I don't even know what's your application type, what is the details of your application, what kind of documents you have submitted. Generally speaking, what I can say, and if you read my articles, you will see that as well. On the bottom of the article, federal self-employed class is probably the most difficult permanent resident application that you could ever enter. So it's a delicate application. A typical application that I submit on behalf of my clients is anywhere between 400 to 600 pages in documents and forms and those kind of things. So it's a very complicated process. But if you do it right, and the officer is satisfied, hopefully they will issue you a permanent residency and you come to Canada. Kartik says, I don't know about IRCC, but would rate you 5-star for your great explanation. Thank you very much. I truly appreciate that. So the next time I will definitely say IRCC. So thank you. So Ashraf Siddiqui says, hi there. Can you please compare between PNP entrepreneur work permit to PR and C11 work permit, and then PR from assurance point of view? Also suggest some practical way to PR from C11 work permit. So of course, the question that you're asking is a very big question. But generally speaking, what I really like about permanent residence through PNP entrepreneurship process is that if you meet the promises that you gave to the province, then you become a permanent resident. It's very It's very likely, unless you are inadmissible to Canada. So that's what I really like about any kind of provincial process for entrepreneurs. It means that you first enter the pool of express entry. Of most of the provinces are like this. You enter the pool of expression of interest for the province. They invite you. You submit your documents. If they are satisfied, they issue you a letter. You receive a work permit based on that letter. You enter Canada with that work permit, and then you start investing, hiring people, managing your business. The province will take a look at your business. If they are convinced you meet the requirements of the province, including the language requirements, then they will issue a certificate of nomination. You pass that certificate of nomination to the immigration authorities, and you become a permanent resident of Canada. So that's a process. Of course, it takes a very long time, but it's a relatively straightforward process. What is wrong with that then? Of course, the problem with the PNP applications is, first of all, provincial expectations. Second, limitations in terms of where you can live. And the third one is competition. So the expectations of the province, for example, if you're targeting British Columbia or Ontario, which many people target those two provinces, their expectations are significant in terms of your net worth, in terms of investment. I don't want to go into the details of that, but that makes it difficult for many people to apply. And what exacerbates this situation is the fact that there is a huge competition. So when you are competing with other people in terms of points, then you cannot stick with minimum investment. So for example, if somebody really wants to have a space in Greater Toronto area to immigrate under PNP or OINPES program, realistically speaking, the investment needs to be in millions of dollars. Otherwise, you have no chance because of the competition, not because of the requirements of the program. And the third one, of course, is the expenses. It's a very expensive process. You need to spend a ton of money in hiring a professional team to assist you with the application. It needs to go through auditing process by a local approved third party. And these makes PNP a tedious process, expensive for most of the provinces. And of course, as I mentioned earlier, the other issue is that you're limited to that province. Now, most people, they want to live in British Columbia or Vancouver, to be more specific, or in Ontario, or to be more specific, in Greater Toronto area. And so if you're immigrating under PNP for Ontario or British Columbia, good for you. You will end up living in where you want to live. But if you are immigrating to other provinces, then maybe this is not your final destination. And getting stuck in a province for several years, that is very difficult for some people. So you need to keep that in mind. In terms of IMPC 11, the more straightforward immigration application for you would be express entry. So what I really like about IMPC 11 is that, with the exception of COVID-19, they relatively quickly process the application. I've had clients from almost 15 countries so far. They relatively process the work permit application quickly. It is under the authority of the federal government, so you don't deal with a province, and then you later can apply under the express entry system under the federal skilled worker class. And if you qualify, then hopefully you can immigrate to Canada through the express entry system. This is the most straightforward process because you receive several points by receiving job offer from your own company. Having said that, sometimes other options will open to you, and I've seen this with my clients. Maybe sometimes when you're in Canada, a provincial option applied to you, or maybe your spouse or common law partner qualifies for immigration to Canada. So the problem with IMPC 11 is that becoming a permanent resident is not as straightforward as PNP applications. However, the process is cheaper, it's quicker, and also because it's federal, then eventually when you become a permanent resident, you don't face many limitations. So none of these two options can be 100% bulletproof or good, but I have seen that majority of my clients prefer IMPC 11 over a provincial option. But if somebody wants to go through provincial option and they meet the requirements, by all means, we accept the case for provincial cases. So that was as brief as I could give the answer. So the big fan, thank you very much. Oh, that's by Lawrence. Thank you very much, Lawrence. I truly appreciate it. So the next question is from Taha, and we already have passed 1 hour time, so I try to be quickly answer these questions. So, hi, sir, the process for work permit from Bahrain, short as they informed me that I don't require medical and no interview. That's great. That's great. So some of the offices, they are very quick in terms of processing applications. So if they process your application quickly, good for you. Why not? This is what we want. I'm an advocate of quick processing of applications. To me, there is no reason for either permanent resident applications or temporary resident applications to take years or months or weeks to be processed. Now, I know that there are some sensitivities around being inadmissible to Canada, but why months? And, it doesn't make sense to me. But anyways, I hope that this will happen for you. So Dozy says, good afternoon. I love your video from Noel. Oh, thank you very much, Noel. I truly appreciate that. Then IRCC should introduce at least a way to change application details. The web form way is old school. And I agree with you, Kartik. So one thing that you need to know is that they are at least, they promise that over the course of September, they will make significant changes to the portal for paid, authorized paid representatives like us. And they are going to make significant enhancements to that. I haven't seen the new platform yet, but I keep my fingers crossed that one of the features that they will add to that platform is a more transparent way of communication with the immigration authorities. So I keep my fingers crossed that happens. But right now, the process is weird, let's put it that way, because when you have an active case, you should be able to communicate about that active case directly to the officer who is in charge of that case. But unfortunately, right now, doesn't exist. So coming to Canada, so this one is from Enrique. Coming to Canada if you are inadmissible. Yes, so if somebody is inadmissible to Canada, I have a video that I explain all different kinds of options that we have to deal with that. So it depends on the case. Sometimes our only option is temporary resident permit. If it's criminal inadmissibility, sometimes we are dealing with deemed rehabilitation. Sometimes we are dealing with a court suspension. Sometimes we are dealing with rehabilitation. Sometimes we have the humanitarian and compassionate option. So it depends on the nature of inadmissibility to Canada. By the way, if you are a practitioner, if you're an immigration consultant, or if you are an immigration lawyer, I'm going to deliver an advanced certificate program on inadmissibility to Canada starting from September 28th. That will be done through Ashton College. If you're interested, you can register to that course and learn more about inadmissibility options. But Enrique, I need to look into your case and tell you whether TRP or temporary resident permit is the best option or the only option for you. sometimes we need to apply for an ARC, authorization to return to Canada. So we need to look into the case and decide what would be the best option. But I have a video about solutions to inadmissibility, and I don't know if I can find it. Yeah, this one. It's called How to Resolve Inadmissibility to Canada. And let me write this down here so I can later post the link below this video. But if you're interested, you can read this article or watch the video. So the next question is, currently in my self-employed file, GCK login shows 62%. Yeah, don't count on that 62% thing. Unfortunately, that doesn't say anything. I've had cases that we submitted the application, and in a matter of 1.5 months, the application was processed. We have had cases that it took them 50 months to process that. So don't count on that, but I hope that this will happen for you. So my first application had a wrong course duration, nothing more, but decided to withdraw that and refile, but just amended the mistake and forgot to tell about the, oh, okay, I got it. Yeah, try to be transparent with them. Hopefully they won't, say anything. And they will pass. And remember, at the end of the day, most immigration officers are good people, and they go through several vetting systems to make sure that they are fair and good people. So in most cases, nothing should go wrong. But during the course of my practice, I also have seen some immigration officers, that they are not fair. And of course, for that, we have a judicial review. For example, for self-employed, I have initiated probably one of the largest judicial review cases against the government of Canada, and it's an ongoing case. And because of the officers that, in my humble opinion, they were unfair. And because this is an ongoing, of course, case, I cannot talk about it in details. But sometimes we encounter those situations. But if we set aside those situations, most immigration officers are good people. They are actually great people. They are fair. They understand the circumstances of the applicant, and hopefully they will process the application fairly. This doesn't mean that they will approve all the applications. Obviously, they refuse some of the applications. But even when they refuse and you review their notes, you realize that the officer was fair. So in most cases, they are fair and good. And in some cases, of course, we have for them judicial review. So good afternoon, Sarah. I love your videos. I wanted to confirm something from you. I applied for tourism visa last year, November. I haven't heard. I haven't got message. Yeah, that's unfortunately, Noel. I can tell you that that is the case. Right now, if you go online, I think they write the processing time for TRV 697 days. Something like that. I had actually a visa that was issued to one of my clients after almost 14 months. Believe it or not, we submitted the application in June 2020, and we received the visit visa for my client in August 2021. But I've had also some visit visa cases that we submitted the application and we received the response fairly quickly. So because of coronavirus, it is common for some visa applications not being processed in a timely fashion. Okay, so delay notice of the decision. I didn't get the question. And the last one, I heard Delhi visa office is worse. I was relieved that my file was not there. Yeah, that New Delhi is now very bad. Yes, whatever Edmonton is, New Delhi is probably worse because they probably do not process. I haven't heard from them for a while. For any kind of application that I have submitted, like a work permit application, sponsorship application, you name it, they are just stuck in there. Okay, thank you very much for watching this video. I truly appreciate your attendance, and please come back next Sunday, every Sunday at 10 a.m. We have a live session. Again, my name is Al Parsai. I'm a regulated Canadian immigration consultant. I hold a Master of Laws from York University, one of the best law schools in Canada. I have been practicing for almost 11 years. I'm the author of 88 Tips on Immigration to Canada, which is has been identified as the bestseller book under the immigration law by Amazon.ca. You can purchase this from any Amazon website. It's called 88 Tips on Immigration to Canada. Also, I teach immigration courses at Ashton College and soon at Queen's University. Thank you very much and see you next week. Bye now.